Hi, everyone. How are y'all? Happy Thursday. Which, yes, our live is usually not on Thursdays. I've been a bit under the weather. So we're back to Thursday like before. And today we are going to talk about student loans and SCOTUS, the Supreme Court of the United States, and the arguments that they had, the oral arguments about student loans. So we're essentially going to tie in the series on my channel, which is usually recorded. It's rarely ever live. We've done one live stream of it, which is my student loan payoff series. So I figured we would just marry the two, a bit of student loan payoff, and mostly a lawyer reacts of the Supreme Court arguments about the student loan forgiveness plan. So this is going to be our agenda, briefly, what I paid in January, and then specifically about the two cases we'll get into. So the HEROES Act and the meaning of modification, because there was lots of arguments during the oral arguments, which was very, very interesting. And then where is Mohela? Mohela keeps getting brought up in one of the cases specifically. We are going to talk about how the state of Missouri and the 5 other states, a total of 6 Republican-led states, are trying to sue when essentially the person that actually has standing is nowhere to be found. Also, I realized that, oh, the mic is on. Perfect. Look at that. And then we're going to get into the fairness argument, which is essentially a whataboutism argument. And last but not least, because this is America, of course, this is a racialized issue, and we are going to talk about what race has to do with who is burdened the most by student loans. And then what is going to happen now that we've had oral arguments, plan A, B, C, and D, and a bit of sip and discuss. So since I'm a little bit under the weather, I'm having water. I hope y'all are having wine for me, and hope all of y'all are doing good. All right, let's get into it. Okay, so this is what I paid in January. So all of my student loan payments are retroactive. I was trying to be ambitious and do this on the 28th, the day that the oral arguments were had. However, I listened to all of it. It was about 4 hours. But I wanted to reference the transcripts, and they didn't upload the transcripts till about 4 o'clock. So that was not going to happen. Plus, I wasn't feeling well. So this is technically February's student loan payoff update, which means this is what I paid in January. It's always retroactive for the month prior. So pretend we're still in February. So in January, I paid $525. Let me move me so y'all can see. Nope, I'm still in the way. Nope, that was better. $525 on January 30th, which brings my February starting balance to $165,273.97 trifling cents owed, which if you've been following my student loan journey, I forgot the beginning of my spiel because usually we never do this live. My starting balance when I started paying off my student loans February 14th of 2020 was $304,680.17 trifling cents. I'm almost at the halfway mark. And also, it's been 3 years. 3 years of consecutive student loan payoff. And child, this is wild. Yes, Candron, we were on time. I would like to know that this is the second week in a row that we are on time. We'll see if we make it to a third week in a row, but we have started on time. So for that, usually I talk about how, the feelings, how it is to be paying off such large amounts of debt. Obviously, I didn't get to paying off almost 160 grand off of $500 payments. Previously, I was making 5,000, 6,000, huge, large payments. So we'll probably save all of that for the end, because 3 years of consistent student loan payoff, I've learned a lot of things. It has been very draining. Some days it's wildly depressing. It has completely altered the life trajectory that I have, to be quite frank. And we can talk about that at the end. So we'll get into what you're here for, which is SCOTUS. SCOTUS versus POTUS essentially is what's going on. So Joseph Robinette Biden has decided that he would try and get some of our student loans forgiven based off of a campaign promise. This has led to numerous arguments, etc., Congress, and there are 2 lawsuits, and those 2 lawsuits have made their way all the way to the Supreme Court of the United States. So this is an old graph, but it is a great graph. So I'll insert Justice Ketanji Brown Jackson where she belongs, but I figured we would use Axios's graph just to show for context why it matters which way the justices are leaning. So we have 6 Supreme Court justices, which are solely towards the conservative side, lean very conservative, and we have 3 Supreme Court justices which lean a little bit more towards the liberal side. Now, Justice Breyer did retire, and we now have Justice Ketanji Brown Jackson, so she does also lean towards the liberal side. I didn't place her because she's new. I'm not sure where on the liberal side she leans. I would assume probably closer to Justice Sotomayor. So on the liberal side, we have Justice Elena Kagan and Justice Sotomayor and Justice Ketanji Brown Jackson. And then towards the very conservative side, we have Justice Clarence Thomas, Justice Alito, Justice Coney Barrett, who she's new, as well as Brett Kavanaugh, who's also new as well. And then Chief Justice Roberts, he leans conservative, but you see where he's sitting. He's kind of sometimes, depending on which opinion, a little bit moderate. And then Justice Gorsuch. Hopefully I'm saying that one right. And essentially, for student loan forgiveness to pass the Supreme Court, for the Supreme Court to basically throw out these challenges, the liberal side is going to need a 5-4 vote. So essentially, we have 3 votes already, most likely on the liberal side. They're all going to vote for dismissing these cases, which are challenging student loans. So they would have to swing 2 conservative justices. Something very interesting as we go through, and you'll see from the question asking, Judge Coney Barrett, she may, in this case, it seemed from the way she asked the questions, she may lean against the 6 states that are stating that they don't believe that student loan forgiveness essentially should be illegal because it will cause those states harms. She's basically leaning on the side of Biden in that case, it seemed by her questions. So maybe we might get a 5-4, but 5-4 in that the liberals who are leaning towards keeping student loan forgiveness would only have 4 votes. Unfortunately, I'm not sure where the 5th vote would come from, but it might be interesting. We shall see. So with that, let's get into it. And we will go through, I have brought a lot of the transcripts so we can pull up direct quotes because there was a lot of back and forth, a lot of bickering, which was interesting. So essentially 2 cases were heard on the 28th. It was Biden v. Nebraska and then Department of Education versus Brown. So Biden v. Nebraska is the case in which 6 Republican-led states are suing, stating that they will be harmed because of the tax revenues that will be lost. And they are essentially suing on behalf of Mohela. Mohela is one of the largest student loan service providers. And we're going to get into why that's problematic and why is Mohela just not suing themselves. And the second case is the interesting case, is the case where 2 constituents stated that they will be harmed because they will not receive the full $20,000. One of them does qualify for $10,000. The other one qualifies for nothing. So why the one that's already going to get $10K has decided to just ditch his $10K? It's interesting. It's very interesting. It should be noted that I believe one of the plaintiffs in Department of Education versus Brown also received a large amount of PPP loans. Just put that out there. So these cases are hinging on Article 3 standing. So Article 3, a standing issue seems to come down to entirely to whether the state of Missouri has standing to sue on behalf of Mohela, which we'll get into that in a second. And essentially, this is from Legal Information Institute. They are great resources. They're a great resource. So for standing, the plaintiff has to have suffered an injury in fact, meaning that the injury is of legally protected measure, which is a concrete, particularized, and be actual or imminent. You have to show that something has happened to you. We are going to focus more on the case with Mohela, the case with Biden versus Nebraska, because that case is more sensible. Neither of them are sensible, but that is a more sensible case than Department of Education v. Brown. When we get Department of Education v. Brown, you can tell that it's not adding up, and particularly the legal argument is very flimsy. So we are going to focus, just so you know what we're going to focus on more, we're going to focus on both of them, but the second one, in terms of the transcripts, with everything is linked in the description box. I'm ahead of it today, so you can read the transcript if you want. You can also listen to it auditory as well. If you're looking at the transcript for Department of Education v. Brown, which is the 2 plaintiffs suing, saying, hey, we don't get $20K, the transcript is significantly shorter than the other one because there's nothing to argue. So Let me make me small so y'all can see. So arguing on behalf of the United States and specifically the federal government, and specifically essentially arguing on behalf of we the debtors who would like student loan forgiveness to go through. It should be noted, and I've said this a million times, I do not qualify for student loan forgiveness. However, I am a big proponent of student loan forgiveness. And I always find it interesting whenever I say that, there's always somebody who does not believe that as a recovering lawyer, a lawyer who worked in tech, that I don't qualify. To which I then have to remind them, like, yes, while math is not my ministry, money is. I made significantly over the adjusted gross income of 125K. And have been very transparent this whole time about how much I used to make as a lawyer. So unfortunately, I don't qualify, but I'm still rooting for y'all. So this is Solicitor Elizabeth Prelogar. I should have practiced these names. Essentially, she did an excellent job. She is a solicitor arguing on behalf of the United States. And if you listen to the oral arguments, just in terms of who did well, because that does make a difference, this whole point is to try and persuade the justices to rule with you. She did significantly better than her adversaries, to be honest. A lot of, regardless of where you sit on the aisle, has stated that she essentially mopped the floor with them. So this is James Campbell. He is the Nebraska Solicitor General. He argued against and student loan forgiveness, and he is arguing on behalf of not just Nebraska, but since he is the solicitor of Nebraska, that's why it's listed there, the totally 6 Republican states. And their argument all hinges on Mohela and Missouri, which is complicated because he's in Nebraska. Don't worry about that. All right. And this is J. Michael Connolly, and he is representing the 2 plaintiffs. I believe they were out of Texas, if I can remember correctly. And the 2 plaintiffs that were arguing that, hey, it is unfair that we are not receiving anything. And because we are not receiving anything, no one should receive anything. Yeah. His case was very flimsy. I'm just going to put it out there. But we are going to give him the benefit of the doubt and go through some of it. All right, so let's start with the HEROES Act and the meaning of modification. This is going to come up a lot if you decide that you want to listen to it. Essentially, the HEROES Act is from 2003. And the HEROES Act stands for Higher Education Relief Opportunities for Students Act of 2003. And we're not going to read this whole thing because it's way too long. But the important part is the HEROES Act was authorized if there is a national emergency. This is post 9/11. So if there is a national emergency, does Congress want there to be limits on student loans, ability to help people who are basically borrowing money from the Department of Education, etc. So the first section has to do solely with people who are enlisted with the United States Army, the National Guard, etc. So that way they can be exempt from having to pay their student loans during times of crisis, if they're deployed, etc. And the part that applies to basically everyone else that is qualifying for student loans is this second part, which I know is super small. Don't worry about it. I'll read out part of it. Authorizes the secretary, and by the secretary, they mean the Secretary of Education, to grant such a waiver to ensure that 1, affected individuals who have received student financial assistance, affected recipients are not placed in a worse position financially in relation to the financial assistance because of their status. 2, administrative requirements placed on affected recipients are minimized to ease the burden on them and avoid inadvertent technical violations or default. 3, calculations of income or overpayment amounts required to be returned may be modified in light of special circumstances. And 4, institutions of higher education, eligible lenders, guarantee agencies, and other participating agencies that are located in declared disaster areas in connection with national emergency or whose operations are significantly affected by such disaster may be granted temporary relief from requirement that are rendered infeasible or unreasonable by the emergency, including due diligence requirements and reporting deadlines. So that is the part of the act that we are concerned with. And essentially, under the HEROES Act, the question is, can the Secretary of State modify or adjust a relief program? The Secretary of State, the Secretary of Education. Can the Secretary of Education modify or adjust a student loan relief program to provide broader relief, to cancel debt, to eliminate debt, etc.? And that is the question here, as well as withstanding. So this is going to come up a lot if you listen to the oral arguments. And essentially, one of the interesting things that is not noted in the oral arguments at all, I don't believe, was who started this in the first place. Currently right now, the Secretary of Education is Cardoza. The Secretary of Education that started student loan forbearance was Secretary DeVos under Trump. No one said anything when they paused student loans. Student loans have been paused for 3 years. No one said anything. Now people are saying something when the debt is looking to be erased at increments of $10,000 and $20,000, which I find interesting because an accounting of how much money individual debtors or collectively the debtors have saved is a large amount of money. And it has largely helped people be able to pay their bills, buy groceries, which you already know how I feel about the price of grapes, be able to pay their rent, etc. It is now that we are moving forward to basically solidify those gains. It's bringing up a lot of questions of alleged fairness. And I say alleged fairness because I don't think that's particularly the issue. So let's get into the transcripts. Let me move this so y'all can see. Okay, perfect. So Justice Thomas started it off. So again, when you listen to it, and you'll see linked down below, there are two separate transcripts because they didn't consolidate them. I thought they were going to consolidate the cases. It would have been easier, to be honest, because the second case is very flimsy. It would have been faster, in my opinion, to have consolidated cases, but they didn't consolidate them. They just heard them back to back. So you'll see that there when you listen to it. Essentially, we're going to go through Mohela, that case first, through the Nebraska case, Biden v. Nebraska, and then with some insertions of Department of Education v. Brown, so you know which way we're going. And because there's so many people involved, there are 9 justices, there are 3 different people arguing for or against student loans. I've put all their pictures on the corner as well, so you can kind of follow along to see who's saying what. All right, so Justice Thomas opens. So just briefly, there's some discussion in the briefs that going past with the provision or the modification or waiver, there was a long, lengthy section, maybe the first, I want to say 30 minutes of the questioning is about the legal terminology of modification or waiver, which is written into the HEROES Act. Now, the way it goes, the U.S. goes first. So you'll have Solicitor Proligar go first in both cases. All right. That is, in effect, a cancellation of a debt. That's really what we're talking about. And that as cancellation of $400 billion in debt. In effect, this is a grant of $400 billion, and it runs headlong into Congress's Appropriations Authority. And I'd like to give you some time to respond to that. So Congress is responsible for the purse, for the appropriations of essentially our taxpayer dollars. And so his question is, why is Congress not making legislative action against this? Why is the executive branch coming in and doing this? Which is a valid question. And to that question, you have General Proligar. Sure. And so first, I want to take on the argument that some amici, those are the briefs, the amicus curiae briefs, that's double, have made in this case about implicating appropriations authority. And this is her response. Of course, implementing this program doesn't require that any money be drawn from the Treasury. And so I don't think it strictly raises an appropriations issue, which is why I think the states aren't raising that argument here. It should be noted that a lot of people, this is their argument. Congress is in charge of the purse. Congress has to tell you what we can do with the taxpayer money. Neither of these lawsuits have even raised that question. Neither of these lawsuits have stated this is an appropriation issue because it's not an appropriation issue. It states in the HEROES Act that the Secretary of Education can modify or waive certain fees. We read through the whole thing. Certain fees, certain amounts of debt, etc. It states that there. This is not an appropriations issue. If it was an appropriations issue, then 6 Republican-led states would have stated this is an appropriations issue and sued on that. They are not suing on that because that is not the problem. I always find it really interesting when legislators, particularly our Congress is a mess, go around and go on different news channels and make things legal issues that are not exactly legal issues. Because again, if it was a legal issue, the Nebraska Solicitor General would have sued on that legal issue. He's not. Okay, and let me make this bigger. Is that big enough? So this is also linked. This is use of HEROES Act of 2003 to cancel the principal amounts of student loans. This is a memo opinion from the General Counsel of the Department of Education. And specifically, it says, I'm going to move me so I can lean in. In 2020, the Secretary invoked, and this is Secretary DeVos, Secretary invoked this authority in response to the COVID-19 pandemic to suspend the repayment obligation and to waive interest payments on student loans for every borrower in the United States with a loan held by the federal government. Prior secretaries have exercised the same authority to categorically waive statutory and regulatory obligations for borrowers residing or working in a disaster area in connection with a national emergency and for borrowers who suffered economic hardship as a result of a national emergency. Again, when DeVos and Trump did this, no one said anything. Everyone was like, okay, yeah, people can't afford their loans. They're losing their jobs. We don't know what's happening. New York was a disaster area. It was awful. Nobody said anything. And it should be noted now that since Biden has decided to declare, I think it goes in effect in May, that he has decided that we are no longer in a potpourri. I'm not going to discuss the merits of that. People are now asking, oh, well, if he's doing that, does that mean we are no longer in emergency? So if we are no longer in emergency, does the HEROES Act not apply? The effects of said emergency are not going to go away in the next 5 years. Certain demographics of people have been irreparably harmed by COVID-19. It's because we live in America. It is a racialized issue. We could go through all the statistics that show which areas have been impacted the most, which families, which demographics. It's not just because you declare that something's not an emergency that it is a non-issue anymore. People are not magically just getting back their pre-pandemic salaries, particularly now where we're seeing huge layoffs throughout many sectors, including the tech sector. All right, let us continue. U.S. Solicitor General, I'm just going to call her Elizabeth because I feel bad I keep messing up her name. Elizabeth argued that in context of the statute, modify has to mean making a change up to the point of wholesale elimination. Correct. It does not say that the Secretary of Education cannot do this. That is not in there. The argument stating that it is not allowed is untrue because then you would have seen Republican-led states, you would have seen even Republican Congress people themselves arguing against student loan forbearance in the first place, which again, in 2020, when forbearance first started and it kept getting extended, it's been extended at this point, I don't even know how many times. No one said anything. Okay. We're not going to focus on the major questions doctrine, but it does come up, so I thought it would be helpful just to mention it. The so-called major questions doctrine is already seeing a lot of attention as I think this is from CNN. Sorry, I usually have all the citations. This is from CNN. Seeing a lot of attention as the red states case is debated before the justices on Tuesday. But what exactly is it? Last term, the court cited the major questions doctrine in a 6-3 decision that curbed the Environmental Protection Agency's ability to broadly regulate carbon emissions from existing power plants. Under the theory, if an agency, so this is any federal agency, acts in a way that could have major political or economic implications, it must have the authority of Congress. To be noted, the Department of Education is a federal agency. So this is why the major questions doctrine is coming up. You see Chief Justice Roberts in the transcripts as well ask questions about this, which is, should we be consulting Congress? And again, the HEROES Act was written, passed, and approved by who? By Congress. And in there, Congress said, don't come asking me every 5 seconds if you want something. I wrote the caveat in here that you can modify. You, the Secretary of Education, can modify. I have other things to do. Go about your business. The states are saying here that essentially the college debt relief plan is too big for the Biden administration to use the authority it is citing. And the legal authorities, particularly the Solicitor General, as well as other people who have opined on this issue, have stated it states in the HEROES Act written by Congress that the federal agency of the Department of Education has the power to modify, and they are essentially modifying it. And it should be noted, which I didn't do the math, but if we were to sit and do the math, the amount of money that has been saved in the past 3 years because of forbearance, particularly the interest. Forbearance also came with 0% interest, which we'll talk about interest at the end, has been significant amounts of money as well. So what is the difference? All right. So where is Mohela? If you're not familiar and you've never had Mohela, Mohela is a student loan service provider. They are a corporation based in Missouri, which the state of Missouri is trying to essentially say they are suing on behalf of Mohela. However, Mohela is its own entity. If Mohela wanted to sue, she could open her mouth and sue, which she is not doing. Mohela wants no parts of this. So this is Mr. Campbell. So again, he is the Nebraska Solicitor General. So he is arguing against student loan forgiveness. So this is the introduction to him. Mr. Campbell, so this is his statement. Mr. Chief Justice, and may it please the court, the Secretary is attempting to bypass Congress. So again, this is their assertion on one of today's most debated policy questions, student loan forgiveness. After many failed legislative efforts, the Secretary of Education, seeks to write off nearly $500 billion in loans for over 40 million borrowers. No statute authorizes this sweeping action. On standing, Missouri has the right to vindicate the harms of Mohela. Harms of who? Not of Missouri, of Mohela. Mohela is a state-created and state-controlled public instrumentality. Mohela is a corporation that performs the essential public function of providing financial aid to Missouri students. It's not just Missouri students, which I find like very interesting that he worded this, because I refinanced one loan right before the pandemic started because I didn't know who's going to know. And when I refinanced that loan, I refinanced it through SoFi. Excellent refinancing provider. When we get kicked back into repayment, I'll probably refinance my remaining 3 loans with them. And the student loan service provider SoFi used at the time, I don't know if they still use them, was Mohela. Mohela does more than just provide student loans to students of Missouri. So maybe he's not too familiar with their services. Now, Justice Alito then asked, okay, let me ask you a question about Mohela, or maybe a question or two. If Mohela itself had brought this suit, would you contest Article 3 standing? To which General Elizabeth states, no, we would not. So we think that if Mohela made allegations that the plan was going to have financial effects on it, it could sue in its own name and we would not contest Article 3 standing. Justice Alito, all right, so then we could consider that Article 3 standing of the state of Missouri, right? So then Justice Kagan then asks as well, because the big question in the room is, why is Missouri bothering to do this when Mohela could just sue? And clearly Mohela does not want to sue, or they would have sued. Justice Kagan, Mohela isn't here. General Crawford, is that correct? General Crawford. Mr. Campbell. Who's Crawford? Maybe she called him the wrong name by accident. Mr. Campbell, Mohela is not here, but to which Justin Kagan butts in. Somebody asked me this question on Instagram. You'll notice a lot of butting in of the justices. They do not care. Their whole goal is they only get 1 hour for each respondent on either side. They just get 1 hour. So their goal, even though it is rude, is to ask as many questions as possible to get to the fact finding and to get to the legal issues. So if you are not answering the question in a way that is going to illuminate anything that they're asking, they will just interrupt you. It's very jarring at first. I've seen like federal lawyers, federal judges do the same thing. The lawyers are used to it, but it is interesting and kind of jarring if you're not super familiar with the court to listen to. You're like, why are they being rude and cutting them off? It is rude nonetheless, but that's how they keep the ball rolling. They're also sometimes a little crotchety, just, truthfully. Justice Kagan, it has the ability, to which Mr. Campbell inserts, its interests are here. See, he was like, I'm going to get my word in. Justice Kagan, to sue and be sued, it's been set up as an independent corporate entity with the ability to bring suits on its own. Usually we don't allow one person to step into another person's shoes and say, I think that person suffered a harm, even if the harm is very great. Hey, boo. So yes, exactly. So now Justice Barrett, just to know why I think Justice Barrett might actually side for student loan forgiveness in this instance, is the way she started asking these questions, even though she is a very conservative judge, is that it doesn't seem she particularly believes that Missouri has any standing. She thinks Mohela does, but by the way she asked the questions, it seems that she thinks that this lawsuit is farce and nonsense. So Justice Barrett, that's Justice Kagan. So Justice Barrett, what's more important to you now is the Lewis and Clark Fund. So separately, because we're not going to get into like all the nitty gritty of it, separately, there is a state fund, a scholarship fund in the state of Missouri, to which student loan service providers were supposed to pay into. Mohela has not paid into that fund for 15 years. 15 years, they haven't paid anything. To which the assertion from Missouri was, oh, but we made a deal with them. They're paying something else, etc. And they're trying to state, oh, no, as Missouri, Mohela's harmed, we're harmed. And essentially, a lot of the justices are questioning this, like, I don't think Missouri is harmed. We think Mohela might be harmed. But again, Mohela is saying nothing. So, Mr. Campbell, no, it's not, Your Honor. What's most important to us is that the state speak directly for Mohela. What sense does this make? But I was responding to the question about the interest that, to which Justice Barris interrupts. I guess I understood the interest to be if Mohela was really Missouri, the loss of the service fees, as am I misunderstanding that? Mr. Campbell, no, you're not. Essentially, he accepts like, oh, okay, I'm going to stop like arguing with them on this point and I'll just reiterate it in a different way. Justice Barrett, you have two different arguments, right? Okay, so then you have Justice Sotomayor. She steps in. This is a question of standing, which relies on injury in fact. How can you have, I'm putting the law, the Lewis and Clark aside. So let's put aside the fact that one of the things, if we were to state that Mohela is an interested party, if we were to state that Missouri is an interested party in Mohela's business, Mohela paying into this fund for 15 years would have shown that, but they haven't paid a cent in 15 years. They are doing what they want to do because they're separate. So Justice Sotomayor is like, okay, put that aside. How can you have injury in fact if you immunize, you the state, have immunized yourself from any liability or any injury that Mohela can experience? So essentially, if Mohela gets sued, the state of Missouri is like, that has nothing to do with me. I don't know her. I set up a separate corporate entity. That's none of my business. We, the state of Missouri, have immunity from all the shenanigans Mohela does. And the question is essentially, you cannot claim you have immunity when they are doing farce and nonsense. And then simultaneously, when you want taxpayer dollars, say, oh no, Mohela's harmed and I'm harmed. Mr. Campbell, because the state speaks for Mohela, he keeps saying this point to which everyone is like, I don't believe it. The state represents Mohela entities. Justice Sotomayor, well, it decided to give this entity the right to sue and be sued. So it chose to say, I'm not injured in fact. Speaking is not the same as injury. So I happen to honestly agree with that. I don't, besides the fact that because it was two conservative-led judges in the appellate courts, that is honestly the only reason why these cases got here. Neither of them has standing. It doesn't make any logical sense. They shouldn't have gotten this far, which is a lot of the legal pundits on both sides are like, why are we even this? They could have sued on other grounds. Suing on other grounds might have made sense. This foolishness. So largely a lot of the second case, which is Department of Education versus Brown, and parts of the first case as well, which is Biden v. Nebraska, focus on this alleged fairness argument. And the fairness argument, in my opinion, is simply a lot of whataboutism. This concept of fairness comes up a lot in the United States because the United States is a fake meritocracy, in that people think everyone should get the same thing. And if everyone gets the same thing, or we pretend everyone has the same thing, everyone will then have the same outcome, which that is not how this works. So now you have Justice Gorsuch. So Justice Gorsuch, what I think they argue that is missing is cost to other persons in terms of fairness. For example, people who have paid their loans, people who don't, plan their lives around not seeking loans, and people who are not eligible for loans in the first place, and that $500 billion is being diverted to one group of favored persons over others. I think it's really interesting to call people who are literally at a disadvantage, because if they were advantaged, they would have paid for school out of pocket. No one is taking on student loans because they are a favored person. They don't have no money. I think it's very interesting to pose it this way without even acknowledging that the statistics have shown that most people, particularly people that have student loans, are in favor of student loan forgiveness, even if you are not receiving student loan forgiveness. But I don't expect, a Supreme Court justice to know what most people are doing. So Justice Gorsuch goes on, and I didn't see anything in the memorandum that dealt with those kinds of questions. And there is something I'd be appreciative if you could point it out to me. So General Elizabeth, no, there's not. But that's because I think those kinds of arguments are inconsistent with the statutory scheme that's Congress set up here. So any type of, I always find it funny whenever I read legal documents and they refer to things as scheme, because usually in like regular everyday layman's term. Scheme is something you do that's awful, like you're scheming, versus scheme here is just how you set something up from a legal sense. Congress already made the judgment that in the context of natural emergency, you should be able to provide borrowers with this kind of relief to serve this purpose. And so I think for the states to suggest that it's incumbent on the secretary to say, actually, I'm not going to do that, even though Congress wanted me to ensure that borrowers won't be left off, it's just at war with the whole statutory purpose. All right. Because again, the statute says, hey, Secretary of Education, you can modify this if need be. So I thought this was a great little graph as to how the hell this sounds when people are like, what about me? I paid off my student loans and nobody should get anything because I paid every red cent. Or what about me? I didn't go to college, so nobody should get anything. It sounds like this. It sounds like an all lives matter argument, which is in this picture, in this comic strip. If we apply that, then if only one person's house is on fire, but you're telling me, well, what about all the houses? And I go and water all the houses. By the time I get to your house, well, sweetie, your house is up in flames, honey. I can't help you. It's gone because you believe in this type of foolishness. Okay, and now I forgot his name. So let's scroll back because this is who's representing in Department of Education versus Brown. So let me go back because we're going to insert some of his now. Okay, so Connolly, Mr. Connolly, he works for a private firm, and that law firm actually takes on a lot of conservative issues, quote unquote. That's essentially one of the main purposes of the firm, which is very interesting. So, but here the respondents were deprived of their procedural right. Mind you, the respondents, he's mentioning his two clients. One would receive $10,000 of student loan forgiveness. The other one does not qualify for any student loan forgiveness, but received lots of PPP loans, which were forgiven. And their finances suffered. Brown got nothing, and Taylor received only $10,000, even though high-income individuals making more than 5 times as much got $20,000. This is a lie, and we'll go through that in a second. The law requires that the secretary give respondents an opportunity to be heard. This is a lie. If you make more than $125,000 adjusted as gross income, you get nothing. If you're a high net worth individual, you make more than $125,000 AGI, you get nothing. So this is not true. Also, $20,000, you get $20,000 if you qualify for Pell Grants. As somebody who qualified for Pell Grants all 4 years, the reason for the you get additional money if you qualify for Pell Grants is because if you qualify for a Pell Grant, that means you come from an economically disenfranchised background. That's only people who get Pell Grants. But as somebody who qualified for Pell Grants all 4 years because I made too much money, I don't get anything. And you know what? That's the way the cookie crumbles. That doesn't mean I'm going to be over here mad and be like, I don't want anybody to get anything. That is a ridiculous way to live your life. All right, General Elizabeth, thank you, Mr. Chief Justice, and may it please the court, because now she's in the second trial now. Across the board, Brown and Taylor's argument is that this case runs counter to precedent and principle. On standing, respondents' asserted injury is a complete mismatch for the relief they seek. That is a nice way of saying this is foolishness and malarkey. They claim to want greater loan forgiveness than the plan provides, but they ask the court to hold the HEROES Act doesn't authorize loan forgiveness at all. A win on that theory would mean that no one gets any HEROES Act relief, not Brown, who would get nothing for herself, not Taylor, who would lose $10,000, and not any of the millions, 44 million borrowers who need this critical relief. Respondents' lack of standing to seek that result, parties cannot go to court to make. This is such a interesting straw man argument that they have made it all the way to the Supreme Court to state. All right. And in any event, this court has never endorsed that kind of circuitous route of standing. Again, to have standing, you have to have an injury. What is the injury? You won't get anything anyway. Saying that you want to get rid of the whole act doesn't fix your alleged harm. You still don't get anything. A plaintiff who isn't injured by agency action can't establish standing by speculating that invalidating that action might prompt the agency to take an entirely different action under a different statute. Do you see how much mental gymnastics you have to say to even make this make a lick of sense? Their whole argument is, well, under the HEROES Act, this shouldn't work because I don't get anything, but we'd like the Department of Education to do this under a different act. No, it's just farce and nonsense. It's just silliness. That's all it is. All right. But this case stands in a very different posture because here their argument is our injury is we're not getting loan forgiveness, and the relief they're seeking, which is a declaration that the HEROES Act doesn't authorize loan forgiveness in the first place, doesn't redress the injury one bit. All right, so Justice Alito then, they are getting back to the fairness issue, quote unquote. All right, I'll try one more time because he continues to ask her this question about, like, what about the fairness? What about the people that never borrowed student loans? I'll try one more time. Why is it fair for people who didn't get arguably comparable relief? Now it may be that their interests were outweighed by the interests of those who were benefited, or those they were somehow less deserving of solicitude. But what is your answer to that question? General Elizabeth, my answer to that question is that Congress has already made the judgment that when there is a national emergency that affects borrowers in this way, the Secretary can provide relief. And you could make this critique of every prior exercise, continue, of the HEROES authority. There too, you could say, well, that only benefited the specific enumerated affected individuals, but it's Congress who defined those individuals, and the Secretary acted properly, giving them relief. Whataboutism will be the death of people. And essentially, it's really an equity versus equality issue. Equality is I gave everybody one slice of pizza. Equity is I know Elizabeth hasn't eaten in 3 days, so I gave Elizabeth 3 slices of pizza and everybody else one slice because I know the rest of them ate 1 hour ago. They're not even hungry. I'm just giving it to them because I feel like it. So Justice Sotomayor then chimes in. I take your bottom line answer to be everybody suffered in the pandemic, but different people got different benefits because they qualified under different programs, correct? Justice Sotomayor. And that's not an issue of fairness. It's an issue of what the law protects, doesn't it? General Elizabeth, yes. To which Justice Jackson then chimes in with the sense, I just wanted to quickly circle back to the fairness point. I guess I'm wondering whether or not the same fairness issue would arise with respect to any federal benefit program. So I'm thinking about that fact. As a result of COVID, we had massive infusions of money given to various companies, organizations, clearly authorized because Congress said to do it. I'm wondering whether that would be unfair to people who didn't own a company or somebody who didn't have, a nonprofit and wasn't getting that money. I just don't know how far we could go with this notion of, to the extent that the government is providing much needed assistance to people in an emergency, it's going to be unfair to those that don't get the same benefit. This is ridiculous, is what she's saying very nicely, very eloquently. Because again, a good example of this is essentially, if America believed in fairness, America would not be trying to gut affirmative action. If America actually believed in fairness, which would be, it is fair from people from marginalized, disenfranchised backgrounds, specifically Black people who have been downtrodden on all these years, 400 plus years. It is fair that these people who we have forced into segregation and Jim Crow, that we give them, etc., help in getting admission to college. That would be a fairness question. But people then saying, what about me? Even though I grew up in the gated community over there, what about you? Do you want me to take down the gate in front of your house? I'm confused. What do you want? Besides to make other people miserable, which is all this is about. It's nonsense and it's very silly. And more than the fact that it's just silly and it's nonsense, it's very dangerous, because essentially what it would do is open the gateway to make a valid legal argument of, what about all these federal programs that I don't qualify for and I don't benefit from? Well, nobody should get anything. As somebody who was a practicing lawyer for over 6 years, I don't qualify or didn't qualify at that time for food assistance, for EBT, for example. Should I then sue the federal government and be like, oh, well, groceries are expensive, I want help too. Screw all the rest of those people. That sounds crazy, because it is. That would be preposterous. If you said that, people would look at you and be like, but you have money. Why don't you just use the money you have? Why are you so angry with poor people? It is a slippery slope to foolishness. Exactly this. Fairness is not as baked into the US as racism is. And largely, the fairness argument is very much linked to racism, which is very interesting, which is the people that will benefit the most from student loan forgiveness as a whole are women. And if you look at it specifically, are Black women. Is it the amount that Black women deserve? No, significantly more. We owe significantly more than $20,000. But that is the largest benefactor of student loan forgiveness, would be of student loan forgiveness, which I think is why you're seeing all of this pushback. All right, so General Elizabeth, yes, that's exactly right. And that's what I would say is that is inherently an aspect of what Congress authorized. And with any benefits program, there are going to be others outside the context of that particular program who aren't getting the benefit. But I don't see how they could possibly provide a basis to say that you are paralyzed in doing what Congress intended to ensure that the class they were focused on gets the relief they need. The class they were focused on gets the relief they need. It's not about you. When people say, what about me? I say, what about you? It's not about you. Sometimes people need to just remove the hubris from themselves and their life. Everyone is not the center of the universe at all times, and that is okay. To which Justice Jackson simply responds, thank you. So I thought this was interesting because then Justice Sotomayor and the counsel who is suing to get student loans thrown out get into a little bit of back and forth. It was just interesting just to show that overwhelmingly, if you look at any news site as to who did well, it was Elizabeth. It wasn't Elizabeth we could be proud of. She did a great job. The two men, the one from Nebraska and the other private practice attorney, they did awfully. I don't know if they were nervous or what it was, or because their case is so flimsy, having to argue a disingenuous case, I would assume must be very hard in front of the best and brightest of the legal field. I would assume that must be a little bit uncomfortable, even if a few of them will blindly agree with you because they are conservative, but you're arguing a disingenuous argument. So Justice Sotomayor then states, but there is no injury that you're suffering unless you get a speculative new plan that goes into effect. You have no proof that if a speculative new plan does arrive under the HEA, so under their argument, they were like, oh, the HEROES Act, we shouldn't apply under that, apply under something else. But again, there are so many tangential mental gymnastics you have to go through for any of this to make sense, which is why none of this makes sense. And you certainly can't say if, so many ifs, they rule against the interest and you have an opportunity to be heard that it was arbitrary and capricious. So I'm at a loss as to how you have standing because there is no notice and procedure required under the HEROES Act. The HEROES Act simply says who the Secretary of Education is allowed to modify it. The Secretary of Education doesn't have to notify any of us. The only way you can win is if you strike down this program completely, and that means that you don't get an opportunity to be heard, but nobody else does either. So you ruin your chances. The only way they win is they ruin everyone's chances. That's it. All right, so Mr. Connolly then chimes in. The secretary created a $400 billion debt relief program under Justice Sotomayor. No, you. I think she had got annoyed, to be honest, at this point. She just starts arguing with him. No, you're arguing what the state's arguing. I'm asking about you. Exactly, about his clients, because again, his case is flimsy. The other case, also flimsy, but this case specifically is nonsensical. Mr. Connolly, sure. Justice Sotomayor, so now she starts walking him through it because she's like, if you want to act stupid, we can act stupid then. You as a student under the HEROES Act, you're a $10,000 student. Mr. Connolly, yeah. Not the disrespectful. Justice Sotomayor is going to get nothing. He's not going to get $20,000. You strike it down, he gets nothing. Neither does your person who wants something. This is so totally illogical. He deserved this. He deserved this, to be honest. He was rude and he was ill-prepared and he deserved this. This is so totally illogical to me that you come into court to say, I want more. I'm going to file a suit to get more, but I know I'm going to get nothing. Because again, what did they file it for? This is a private firm. They filed it because conservatives hate poor people. And because the conservative party, despite what they want to say on Fox News, is not a party of the people. It is a party of the few rich white people who have bamboozled the many poor white people. But again, it's not my ministry to convince poor white people of that. That's for somebody else. But that is exactly what's happening. Mr. Connolly, so the secretary created And also the way the court reporter works, the court reporter has to write verbatim what you say. So if you get nervous and you start stuttering, the stuttering is in there. So the secretary created a massive debt forgiveness program. And he says that he's doing it one time and one time only. He said this in his brief, mind you, he's throwing out 400 billion, massive debt. These are just sound bites for conservative talk shows like Fox News. He said this in his brief, in his declarations on its websites, and in the reply brief. He said he took costs into account. And so if we miss this shot, we will never have another opportunity to get debt forgiveness. He's saying if he misses his shot for his clients to get debt forgiveness, he will never have an opportunity. But he's using his one opportunity to torpedo said debt forgiveness. I don't believe this man to be stupid. So clearly he knows that this is illogical and he's just arguing it anyway. Okay. Justice Sotomayor, no, you can. The general said you can. Justice Jackson, I don't know if that helps or hurts you. Because at that point, she was also equally annoyed of, are you not understanding what you're saying? I think you are, but like, you still, okay. All right. And of course, because it's a racialized issue, I would be remiss to not include the part that we included the last time we did a student loan forgiveness live, which is like a while ago, which was who benefits the most and why student loan forgiveness is not only needed. Honestly, this is not enough money. I've already said this before. So this idea of keep throwing around, this is $400 billion. The Ministry of War is what it used to be called, aka the Department of Defense. Their budget is over significantly higher than this. If we were going to ask questions of where is the federal budget going, that would be a better question. Also, it should be noted that for 3 years, it is over 90% of people who owe student loans have not paid a red cent in 3 years. The Department of Education has not somehow magically combusted. Nothing happened to it. All those payments, 365 times 3, so many days, and the Department of Education is still standing. Seems to be doing just all right. Doesn't seem like anything is going to combust if we forgive student loans, which again, this is not an appropriations issue because we're not taking the money from anywhere. The money exists on a computer screen that for some odd reason, people have decided to, not look into. Which if you saw my Instagram story the other day, you know exactly what I'm saying. All right. So the average student loan debt, this is from Education Data Initiative. I wanted to share this again, just so we can conceptualize who owes so much money. The average student loan debt 1 year after graduation by race. So my only qualm with this graph is the same qualm I had last time, which is not to be that person, but to be that person. It would have been easier to read if they separated us out by color, by shade. But you have in order Hispanic and Latino, Black and African American, white and Caucasian, Asian, American Indian, Alaska Native, Native Hawaiian, Pacific Islander, and multiracial. We're going to focus on Black and African American versus white and Caucasian because that is where you see the largest disparities. So in the darkest blue, all the way towards the left-hand side of the graph, that's people who owe 0 to 10,000. It's 9,999. Let's just say 10K. And then while it looks the same, it's not the same. In a little bit less darker blue next to it, you have the 10K to 25K people. In the maroon, the scarlet reddish, you have 25K to 40K. And then in the new set of dark blue, almost all the way towards the right, you have 40K to 60K. And then in the gray, you have the largest amounts of debt, 60K plus. Now, who owes the highest amounts of debt? Black people. Specifically, the most educated demographic in this country now is Black women and has been for the past 2 years because largely Black women, we make 61 cents to a white man's every $1. We're only getting into these jobs, sadly, when we do have the extra credentials just to get underpaid to then struggle to pay off the damn extra credentials. So 17% of Black people owe over $60,000. The average student loan debt hovers around 30K, and then for Black people hovers around 40K, and that's largely because the 100K and up people, we owe so much money. We are dragging the average up so high, and if they did studies just on who owes over 100K, largely the people that owe over 100K is Black women who have gone on to higher education. It's the lawyers. And again, not all lawyers make 6 figures. There are plenty of lawyers that never make 6 figures a day in their life. It is a misnomer that lawyers are well paid across the board. We are not. It is people who have gone on to get their MBA. An MBA used to be a surefire way into a six-figure job. Now, because the MBA costs so much, an MBA will get you a low six-figure job sometimes, and sometimes a job that doesn't even make six figures. I've known people when I worked in tech, they were CSM, customer success managers, what a CSM is, and had MBAs and made $75,000. You owe 150, you making 75. Obviously, there's a discrepancy here, and so on and so forth. So again, it's very disingenuous when we have these conversations. And I meant to put that because that is actually, I want to make sure. I think it was Chief Justice Roberts who said it. I'm not sure. It was a man who said it, one of the justices, and it wasn't Clarence Thomas. So I'm trying to remember the voice, where they stated in their fairness argument, which was, when you go to college, is it fair for people who went to college and amassed these student loans to get forgiven when people who have not gone to college, they statistically make less? That was a statement from one of the justices. That is not true. That statement largely erases any type of, oh gosh, how did I forget the word right now? Any type of analysis by race, ethnicity, gender. The word is escaping me. By Kimberly Crenshaw. I'm seeing her face and not the word. I don't know. Y'all remember what the word is. Intersectional. I was like, why is the word? It is that completely erases any intersectional analysis. If you look at an intersectional analysis of how much money, Roberts, thank you, Susie. I thought it was him, of how much money we're all making in this place. College educated white women, black women, college educated, college degree, 4 years, make the same, if not a little bit less, than a white man with a high school degree. To make the same amount as a white man with as a white woman with a college degree, you need an advanced degree as a black woman. It is a harmful and untrue statement to say everyone that went to college is doing so much better than people that have not gone to college. That is not true for black people. That is not true at all for black people. And it is very interesting when these types of things get thrown around. And we talked about this last week in our live, where we were talking about Potomac and patriarchy and prenups, and specifically in the idea that America believes itself to be classless. And now America's like, okay, we're not classless, but basically the haves and have-nots, and we define that as anyone that goes to college in the American psyche is somebody who's doing well. They have a lot of money. They have disposable income. And this is from the Psychology Today. It was from an article. That is what Americans as a whole believe in their mind. They believe if you have gone to college, you're doing so much better than someone who hasn't gone to college. I'm like, that is not true. It is not true for black people whatsoever. Black people who have not gone to college, unfortunately, or have not finished, largely are living in poverty, as well as some black people who have gone to college are also living in poverty. So it's very annoying that these statements can be made. And because, again, this is the Supreme Court of the United States, we are having a legal argument where largely illogical ideas of fairness are being used. And I do think if I had one critique of General Elizabeth, I thought she did a great job sticking to the legal arguments. Every time they brought up fairness, that's not a legal argument. She dragged them back to, do you want to talk about arbitrary and capricious? Do we want to talk about that? Do we want to talk about modification? Do we want to talk about actual legal standing? I do think it would have been helpful for her, however, to have combated that with some statistics of, I understand you're saying that, however, it is untrue, that statement. Which, to be fair, I'm not sure if she's even aware of. To be fair, unless you are an affected person by these things, you are largely unaware of these issues. But then have the audacity and the caucasity to be talking about fairness. That is what really grinds my gears and gets on my last nerve. Because I can't bother with it. It's very interesting. So I would say that would be my one feedback and pushback, which is if you know that your opponent is going to bring in the words of Justice Sotomayor, an illogical argument, be prepared with your logical rebuttal that might not be based in legal doctrine. Because no, our legacy of racism and how it affects people, while it was originally codified into legal doctrine, is not based in a legal doctrine. It's based on white supremacy. So that was my 2 cents on that. And one of the things I wanted to know as well with this, and that neither of these cases is bringing up, is the benefit of student loan forbearance all these 3 years, it's been 3 years now, has been we have paused interest. And we have saved so much money in pausing interest because, again, this budget is coming from, is sitting there. It's money sitting to be collected. If everyone decided not to pay it, clearly for 3 years, 90% of people have not paid it. Nothing has happened. Nothing awful has happened, but there are actual implications for these, for the student loan systems that have been put in place, and all of them are very negative. So I wanted to put a little clip from last month's student loan forgiveness update, just so y'all can see just how nefarious our interest system is set up. All right, let me make this big. Prior year. Listen to this. So I paid last year, according to my Form 1098E, which I marked down. It'll be on the screen because I can't remember right now off the top of my head exactly how much I paid total. It is around $30,000. The exact number will pop up on the screen in post-edit for me. Out of that total number that I paid towards my student loans in the year of 2022, guess how much of that was interest? I'll tell you. $15,809.33 trifling cents went to interest of my hard-earned pennies that I paid down towards my student loan. Which is wild. That's half. Half the amount that I paid last year went to interest I owed before the pandemic. How is anybody supposed to pay that off? And again, the only way I was able to pay off $30,000 in 1 year, which for me was a smaller amount because halfway through the year I started doing content creation full time, is because I was one of the few people that actually made 6 figures and worked in a corporate job. Most people do not make 6 figures in America. We're not having realistic conversations about people's real life salary. So if you owe all this money and the money just accruing, it's not designed for you to actually ever get out of debt. So again, it is extremely harmful. It's past disingenuous. It's incorrect. And it's harmful to say just because people have a college degree, they are automatically doing better than people without a college degree. That's not true. It is true for white men. Yes, then say that, Justice Roberts. As a white man, he should have said, as a white man, I have done better because I'm a white man and I am a white man with a college degree and a law degree. That would have been a correct statement. That would have been correct. But the blanket statement of if you have a college degree, you're doing better. How? When the shackles of interest are holding you down. It's not possible. Okay, don't play again. Don't, shush. Okay, so what happens next? The important parts of what y'all want to know. Exactly. Interest is financial servitude. It is. It changes the trajectory of your life. Changes the trajectory of your life when all of a sudden you borrowed, I think, what was the original? We've done it before. I think I borrowed $240 maybe. And then all of a sudden I looked at it and I owed $304. I was like, I didn't borrow that. Where'd that come from? If I actually only had to pay what I borrowed, I've paid now $160. I would owe less than 6 figures now. That would be okay. I could breathe a little easier. But no, I owe $165. All right, so there are a couple options as to what happens next. They're likely going to decide the Supreme Court is really slow, like June, most likely. However, they have stated they're going to expedite this issue, which they have to issue an opinion. They have to vote, and then they have to issue the opinion. So the law clerk will write it, they'll review it, etc. So maybe it will be sooner, but the guesstimate is June. Maybe that will happen. You likely got an email if you are a federal student loan debtor from the Department of Education. It looked like this, which essentially the only important part that matters. While we await the Supreme Court's decision, the pause on student loan payments remains in effect. Payments will resume 60 days after the Supreme Court announces this decision. So if it happens in June 1st, that's what, June 1st? July 30th, that's like August 1st, that'll get you. It depends. Or it's going to be 60 days after June 30th, which I don't know why they just don't give the date for what 60 days after June 30th is. It's an interesting way to write it. So essentially that's if they haven't resolved litigation by June 30th, then student loan payments will resume 60 days after June 30th. Now, there's also talk on the street that if this doesn't go through, that the Biden administration may modify the plan and try it a different way. That's possible. And there are also further, mind you, these are all guesses by people who follow this every day, different news reporters, different alleged sources in the Department of Education, which state that most likely student loan forbearance might go through till the end of the year as Biden tries to figure out student loan forgiveness. It should be noted from a political standpoint, this was his campaign promise. I'm going to say this with the most serious and not try to be funny, but he is of the mindset that he wants to run again in 2024. That's interesting. And he will not win. He really shouldn't run again, but he will not even get any votes unless he keeps this on the table. So it's in his best interest to, at the very least, keep dragging forbearance out. So we're going to see what happens. Nobody has any answers. It's going to be very interesting. I do think at first I would say my legal opinion was very much oh, it's a very conservative leaning court, 6-3. This is definitely getting thrown out with a 6-3 vote, 6 against student loan forgiveness. I think the vote might be closer, but I'm not sure that they have gotten 5 votes because some of them, Clarence Thomas hates everyone. So, of course, he's voting against student loan forgiveness. Justice Roberts was very clear that he doesn't think it's fair, which is comical as somebody who has received so many benefits of being a white cishet man in America. So he's obviously voting against it. Justice Gorsuch didn't say too much, so we'll see. Alito seemed to be very much against it. So, and then Kavanaugh, he went with, the cishet white man argument of the fairness again. I think it's really interesting who is arguing fairness and their particular identity. That part is not the people who should be arguing yes, this is fair. Very, very interesting. So we're going to see what happens it's March, in a couple months. So on that note, let's look through a few comments and then I'm going to go drink some water and eat my dinner. All right. And this is a good point. The PPP thing is what pisses me off. So much gumption for people who received loan forgiveness. I find it really fascinating that the same people who I don't see people largely complaining about the PPP, some of them were correct, I suppose, and actually legally deserve their loans. And a lot of them were scamming. A lot of rich people or rich famous people have been purported to be wait, what do you mean? You have that's interesting. I don't see people up in arm about the PPP loans. Fascinating. Very fascinating. Maybe we should try this. I'm going to sue the federal government for damages because I didn't receive PPP loan forgiveness. It's such an interesting thing for people to say, well, I'm not getting it, so to hell with all of you. It's wild. It's a wild, wild thing. I love when the EU and the rest of the world comes to roast us. Meanwhile, I'm living in Germany where higher education is free. I love that for you. Get that good education. All right. And this is it, Angela. America doesn't give a damn about fairness. It's very interesting, the specific language always used, particularly by conservatives, that when you hear the language on its face, the word fairness, it's of course we all believe in fairness. Of course. And then they twist the word into this ugly thing. You're that's not about fairness. This is about whataboutism, and you want everyone to sit in misery with you. All right. I agree, Ashley. We'll end on this one. Relieving student loans would give too much of a level field to play on for other people, I believe. I definitely owe just about the same amount on my student loans as my mortgage. It would free people so much. So, for example, I owe $165,000. The reason why I was able to pay off 160, I think I'm at 160 paid now. I don't know. I didn't calculate all the interest when I first started paying it off. So that $304,000 amount is not the total amount I owe. I owed more than that, which is wild because they hide it from you. They tack on your capitalized interest, which they're finally getting rid of. They're not doing anything retroactively, which is a problem. And so if the reason why I was able to pay off so much money in 3 years, few reasons. One, I made enough money as a lawyer that worked in tech. My highest salary I made was $165,000 base salary. That's a good salary. That's a good salary. I live very cheaply because I don't have any children. New York is expensive, but I don't live in an expensive neighborhood. And that deficit that I had in my budget was allowed me to pay off all the student loans. Without $165,000 owed, I could do whatever the hell I want to do. I literally have to work to ensure that I pay the loans off. But without that, like, my life only runs me like $3,000 a month. It's not very expensive to be me. So I think that's largely what it is. It is this idea of that is a reality for many people in the United States, which is forced poverty. America runs on capitalism, and capitalism runs on cheap labor. And the byproduct of cheap labor is forced poverty. So, on that happy note, I will catch y'all. What do we have coming up? We're going to do our resorts and plantation video. I started doing the outline. I'm reading this great book. I highly recommend. Black Ghost of Empire, The Long Death of Slavery and the Failure of Emancipation. Excellent book. It essentially ties in all the different emancipations from the United States, the Caribbean, and South America, as well as the colonization of Africa and how these different emancipation laws didn't give us full freedom in any of these blasted countries. So excellent book. I'm going to be using that as one of the sources for our plantation to resort pipeline, whatever I title it, video that we're going to do. So that's coming up. And then what other things do we have? Y'all let me know any things you're interested in. And yeah, I appreciate y'all. And it's going to be, I have a toddler who's in my pockets. Yeah, kids are expensive. Very cute though. So cute, but so expensive. But yeah, so we have those coming up. And I feel like there was another video I wanted to do, but I can't remember off the top of my head. We are still going to do the throwback lawsuits, or the throwback lawsuits. I think we're still going to do throwback lawsuits, even though legal drama shows won, like those types of reviews. So I've started the research for Law and Order SVU. And by research, I've just been watching a shit ton of Law and Order again, because I haven't watched it in years. But I used to watch it all the time. So those will come up like sporadically. So if you ever want any specific videos, I have like a few like community tabs with the question on them. So I check them periodically. So you can always write them on there, or you can, I always ask like once a week on Instagram too. So just pop in. All right. Well, I catch y'all later. I hope y'all feel better. Oh, the name of the book. Here you go. Black Ghost of Empire, The Long Death of Slavery and the Failure of Emancipation. I'm like a quarter of the way in. It's excellent. Excellent. Great sources. Because I like that it ties all of it together, because we have such similar experiences, and you can't really talk about emancipation in one place without talking about emancipation and slavery in the other place, particularly because one thing would set off another. Like the Haitian Revolution set off the crackdowns on enslaved Black people in both the US and in the Caribbean, as well as South America. So it's very interesting. So I appreciate y'all, and I will see y'all. Today's Thursday. Yeah, I'll see y'all next week. All right. Bye. Stay warm.